My name is William S. Harris. I go by Bill, and I have been practicing law here in Tarrant County for 40 years. If the gun owner has used his firearm in self-defense, not the police, they should first off know that they are not necessarily going to get a pass. They are not going to, they can't reasonably expect that they're going to go back inside and go to bed and then come down and chat with the DA or the police the next day. The odds are they will probably, particularly if somebody's dead, they will probably be taken into custody. Now, there are exceptions to that rule. I'm not going to say that every time a firearm owner uses his weapon, he is necessarily going to jail, because there are some situations where it is manifest at the time that this person acted in self-defense. For example, somebody is robbing a mom and pop's convenience store, and there is not just the owner of the store, but somebody else there. The police arrive, the owner has used his gun, the guy who was going to rob him is lying on the pavement. There's a gun near, but not, let's say, in his hand. Maybe it's kicked away from him just to be safe, or it's in his hand. Now that's the other thing I will say. I talked about not messing with the scene. There's qualifications to everything. If you've got somebody that's shot down and may or may not be deceased, and that gun is still in his hand, there's nothing that requires you to, in my opinion, to leave that there. Maybe that is tampering with evidence, but it is such a minor tampering with evidence. And so, just use reason. I would make sure the gun is out of his immediate possession, and then tell the police that you did that. So that's one of the caveats, but or be willing to explain that later. I don't know that I necessarily advocate trying to explain that to the police. If they get there on the scene and that guy is laying there and the gun's 5 feet away from his hand and it's still laying there, your gun is secured, you're the owner of the store, and maybe there are other witnesses that confirm that this guy was trying to rob you, you may very probably not be arrested that evening. Same thing might be true if there was an equivalent situation in your home. Now, on the other hand, if the person who is laying there deceased is your brother-in-law, with whom you are known to have had bad relations, and he's on the front porch and you're standing inside the entryway, you may still have a perfectly good claim of self-defense. But it's not the policeman's job to determine whether the defense is good or not. That's up to the legal system. He may well decide under that situation, following his department policy, that you must be arrested, taken into custody. Then you will need to have somebody in your family make bail for you, possibly contact a lawyer if the bail is too high and try to get it reduced. But you should be prepared to be arrested if you have used that gun in self-defense, whether the target is deceased or merely injured. You should expect that that is a possibility. And don't try to talk your way out of it at the scene. You will absolutely mess it up. I would not try to do it, and I know the law of self-defense fairly well. That's not the place to argue that.